very warm welcome to all of you watching this video. As we all know, we have started with this recap batch for CA Foundation Business Law, that is our paper 2. Now, today is lecture number 1 of this recap batch, and the agenda is we are starting with this humongous chapter of the Indian Contract Act 1872. We begin with unit number 1. Now, this chapter comes with almost 9 units to study, but unit number 3 being the biggest one and the most important one. Unit 1 is very basic in nature. It's just trying to give you a basic understanding of all the contracts, of how contracts are created, of the different types of contracts. So, let's go straight into it and let's cover it up as soon as possible. Now, before we move ahead, just to give you a small overview of the Indian Contract Act, we have 266 sections in the Indian Contract Act. The range from 101 to 175 deals with the general provisions of the contracts. Okay, now this general provisions is what we are going to study almost in the entire Indian Contract Act. Also, to tell you, okay, I'll take that up later. Next, we have 76 to 123, which deals with sale of goods. We have 239 to 266, which deals with partnership. Then we have 124 to 147 that deals with indemnity and guarantee. 148 to 181 dealing with bailment and pledge. 182 to 183 dealing with agency. Now, why have I marked them differently? This range of sections and this range of sections has been eliminated from the Indian Contract Act. Why? Because now they have created two completely new chapters, that is the Sale of Goods Act and the Indian Partnership Act. Okay, so we don't need to study this much in this chapter. Is it out of the syllabus? Of course not. It is a part of the syllabus. We'll be studying it later. This is still a part of the syllabus, and this is the majority of the syllabus. So section 1 to 175 of the Indian Contract Act is majority of the syllabus of the Indian Contract Act at CA Foundation. These three, if you remember watching lecture 0, you will remember me telling you that some additional units have been added into the Indian Contract Act, which have been borrowed, which have been robbed from CA Inter and have now been clubbed into the syllabus of CA Foundation. Okay, which are they? These are these very chapters of indemnity and guarantee, bailment and pledge, and agency. These are known as special contracts, and these are new new new. Okay, new. So from this, will it be wrong or will it be right for me to say that this much is basically the syllabus of old course, right? This is the syllabus of old course. This and this was never a part of Indian Contract Act. These are two separate chapters, and this is the addition in the new course. Okay, so what will our Indian Contract Act look like? We will start first by studying all the general provisions. We will be investing 90% of, or I would say 80% of our time in studying this area, the general provisions of contracts. If you remember, I also told you very specifically in lecture 0 when we were discussing the syllabus. I told you the first part of our syllabus, when I gave you this bird's eye view, I told you the first part of the syllabus deals with contracts. Under that, we have a very specific type of contract, that is sale of goods. This contract of sale of goods is covered under this chapter, and all the other contracts, all the other general contracts are covered under the chapter of Indian Contract Act. Okay, so again, now over here, all the other contracts, all the general provisions of contracts we will be studying in this area. After that, we will discuss some special contracts, and that will be it for our Indian Contract Act. Now, coming to this chapter of Indian Contract Act, if somebody asks you today that as students who are preparing for an exam like CA, if you can just tell us what are contracts, the very spontaneous answer that most of us before we study the subject of law is that contracts are probably agreements. Contracts are something which we agree on, they are agreements. But today I would like to tell you that henceforth, never ever as students we are going to say that a contract is an agreement. That statement is incomplete. That statement is wrong. You cannot say that contracts are agreements. That is incorrect. Okay. Now, but what are contracts then? Contracts, simply speaking, are a part of our day to day lives. Everything that we do in our day to day lives, be it from engaging lectures, be it buying classes, buying a movie ticket, your gym memberships, your sports memberships, your tickets for IPL matches, whatever you do in your day to day life, whatever commercial transactions you're doing in your day to day life are nothing but contracts. Nothing but contracts. Okay, so you understand how wide the applicability of this law is. Okay, now I've just put it down here for you. So almost everything that we do in our day-to-day lives can be related with the Indian Contract Act 1872, right from buying a movie ticket, biscuits, restaurants, Amazon orders, classes for CA, etc. Now, if I say that I entered into a contract with Mr. So and so, or if I say I entered into an agreement with Mr. So and so, are these two terms the same? Is a contract equal to an agreement? No, no, never ever again in your life will you say that a contract is an agreement. Understood this? Okay. Normally, these two words seem very synonymous. These literature and English students very righteously say that contracts are agreements. But we as CA students should be able to correct them that you are highly mistaken, sir. Contracts and agreements are never ever going to be the same. Therefore, a contract is never equal to an agreement. Why? Why? What is the difference between a contract and an agreement? This is the discussion that I'm going to take up over the next almost 30 minutes, right? Okay, so please pay attention. Please understand this once and for all. This discussion of how a contract is created is going to set your base for the next 5 to 6 lectures. So please pay attention and keep on understanding the concepts as we move ahead. Rather rather we will say that in order to create a contract, we must have an agreement first. So contract is like that final destination where we have to reach. Contract is like that last place that we are trying to reach. In order to reach that destination, we first have to cross something known as an agreement. This is what I'm trying to tell you. I am trying to tell you that in order to reach somewhere, there is a road which you have to take. In order to reach a certain destination, there is a pathway that we have to follow. That pathway is what I call the agreement. That destination is what I call the contract. Okay. Now, so if I tell you that in order to reach a contract, you first have to go through an agreement. It's not the other way around. In order to create an agreement, you don't need a contract first. So if I tell you that in order to reach a contract, you first must have an agreement, which term is a wider term? Will all agreements become contracts? Not necessarily. All the cars that are going to the destination need not necessarily reach the destination. Some may meet with an accident, some may change their mind, some may come back, some may take the wrong road. Only those cars that reach the destination will get that crown of being called a contract. Therefore, all agreements, that is the cars, may not become contracts, but all contracts necessarily, compulsorily, mandatorily have to be an agreement. In order to become that person who won the crown, you have to first take this role. Therefore, contract is a narrower term. Okay, agreement is a very wide term. Agreement is a very wide term. All agreements are not necessarily contracts. All cars may not necessarily reach the destination. But if you have reached the destination, then you are definitely a car that once undertook the journey. Clear? Okay. So this is one such question which they ask in the exam. All agreements are not contracts, but all contracts are agreements. Please comment on this. This they can ask you for 3 marks. You should be able to explain this. Now, how are contracts created? Okay, it's not so simple. Right now, I've told you that in order to create a contract, you have to first make an agreement. So you make an agreement, contract is done. Simple. This is not how easy. I mean, this is not as easy as it seems. Okay. So if the next thing that we are studying is how are how are contracts created? Okay, how do you think contracts are made? We'll take a simple example. I am a faculty for the subject of law. I'm teaching you law right now, and let's say you have decided to buy classes from me for your CA Foundation law syllabus. This is basically a commercial transaction. So, right from now till the time we enter into a contract, how will this process look like? Number one, I am first going to put up an advertisement saying that I'm going to be taking up classes for law. I'm going to be teaching in so and so manner, so many hours, so much price, so many questions will be covered, so much coverage will be given, test series will be given, blah, 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 blah. This is something that I'm making to you is known as the proposal, right? Am I not making a proposal to you? I'm making an offer to you. I'm stating very clearly to you that these things I'm offering to you. So, number one, first thing that I make to you is the offer. Now, you see the advertisement and you decide that, okay, this seems pretty good. Let me subscribe to this. Let me buy this. You decide to accept my offer. You accept my proposal. You say, yes, sir, we are willing to buy your lectures. So now, when I gave you an offer, you accepted that particular offer. What has happened here? I have offered to teach you, you have offered to pay me. I have promised to teach you, you have promised to pay me my fees. So, in such a situation, when an offer is accepted, it becomes a promise. I made an offer to the students. Students accepted my offer. Therefore, after my offer is accepted by the students, I have made a promise to the students to teach. Students have made a promise to me to pay money to me. Clear? All right. Now, okay, so offer is made, acceptance is made, promise is made between both the parties to do something for each other. Okay, not a problem. Now, let me give you an example. This example is clear, I hope, to all of you that I made an offer to teach you law. You accepted my offer, and therefore I promised you to teach, you promised me to pay my fees. Now, just now, what possibly can happen if I don't teach you? If I take all the fees from all my students, and if I don't teach you, obviously you all are gonna file a case against me. You all are gonna recover the money back from me. You all are gonna drag me by my collar to the court of law. But say suppose this situation was somewhat different. Say suppose I had made an offer to my mother at home that if you can just make something good for me, maybe a pizza, and I will bring a ring for you if you make a pizza for me. So I've made an offer. She accepted my offer. No problem. What promise have I made to give her a ring? What promise has she made to prepare a pizza for me? I come back home and she hasn't done her promise. Can I drag her to the court of law? Obviously not. Why? Not because I'm scared of her, but because this was not the intention of this. We never intended to drag each other to legal courts. We never intended to file cases against each other. No doubt there is an offer. No doubt she accepted my offer. No doubt I promised to give her a ring. She promised to give me pizza. But all of this, we cannot, if something is not done here, we cannot drag each other to the court of law. Okay, just keep listening, and keep fitting things into your head. Now, firstly, Firstly, I make an now we are considering this particular contract of sale of online lectures to students. So me as a faculty, I made an offer to you that I will teach you law. Will you buy my classes for rupees so and so? As of now, my classes are free, but if you all like it, I may charge you in future. Okay. Three of you, say, suppose said, "Oh wow, yes, sir, we really want to buy your classes." Fine. So you all agree, you all accept my offer. Two of you don't accept, no problem. Not everybody has a good taste, right? So two of you don't like my classes and you all reject the offer. So you either accept it or you reject it. You either accept it or you reject it. If you accept it, we go ahead. If you reject it, that is the end of it. There is no contract going to come into picture. Okay. So what did I do? I made an offer to you. What did you do? You either accept the offer or you reject the offer. So step number 1 was making of an offer. Step number 2 was acceptance being taken by you. Once you accepted, what has come into the picture automatically? Two promises have come into the picture. When an offer is accepted, two promises come into the picture. What are they? My promise is to teach you, your promise is to pay me my fees. Clear? Okay. If you accept the offer, then it becomes a promise. Therefore, I have promised you to deliver the lectures, whereas you have promised me to pay me my fees. Okay, no problem. So each of us, don't you think each of us, me and my students, have to do something or the other for each other? Right? I have to teach you, you have to pay me my fees. I have to teach you, you have to pay me my fees. You buy a movie ticket, you have to pay the money, they have to show you the money. You buy a bus ticket, they have to give you bus transport, you have to pay them money for the ticket. Any particular contract you do, there will always be this promise by each other, which we term as reciprocal promises. What is reciprocal in your quantitative aptitude? Reciprocal of 2 is 1 by 2. Basically, ulta, right? Upside down. So, here again, reciprocal promises. I will do something for you, you do something for me. मैं तुम्हें खून दूंगा, तुम मुझे आजादी दो, right? Okay. Both of us are getting something in return. Don't you think both of us are getting something in return over here? What am I getting? I'm getting money. What are my students getting? They are getting brilliant law lectures from a faculty like me. So this something in return in legal languages we call as consideration. Consideration. Always remember always remember one thing. What is consideration? To tell you in the simplest of languages, me giving law lectures to you, you paying my fees. Consideration for me is, for supplying law lectures, I'm getting fees in consideration. For giving me money, you are getting law lectures in consideration. So consideration is nothing but these reciprocal promises which both the parties have made to each other. Clear? Okay. Now, consideration also has another very famous term known as quid pro quo. Okay, I really expect you all to know all of this and gone through the module once before sitting for these lectures, right? Okay. Now, so we have successfully entered into an agreement. We have successfully done an agreement. So, what have we done so far to reach this particular phase of an agreement? What have we done? If you can tell me, what have we done? I gave you an offer, you accepted my offer. Once you accepted my offer, what has happened? It has given rise to two promises, right? I will deliver lectures to you, you will pay me my money. We termed this as what? As consideration, right? So when all of these things are fulfilled, offer is given, acceptance is received, that becomes promise. How many promises? Two. What are these called? Reciprocal promises. These reciprocal promises are also known as consideration or quid pro quo, right? When all of this is completed, when we finish this much work, we will call this as an agreement. Okay, have we reached the destination yet? Have we become a contract yet? No, we are just entering into the car. We now have to start moving towards contract. We are not yet a contract. This delivering law lectures to you is not yet a contract. It is just an agreement. There is one more additional thing which has to be done. We have successfully entered into a contract. Now now in order to become, we have successfully entered into an agreement. Now, again, I've written a summary here for you. Okay, so I made a proposal or an offer to deliver lectures to you. You accepted my offer. You accepted my offer. Once you accepted my offer, it has now become a promise, right? It has now become a promise. What are these promises? These are two promises made by two people to each other. We call them reciprocal promises, or simply we call them consideration. So now, when you have an offer which is accepted, it becomes a promise. Promises which form consideration for each other, that they are termed as an agreement. So we have now created an agreement. Now, in order to make this agreement a contract, there is one more thing that has to be present, right? One more thing that has to be present. Now, I gave you this particular example. I told my mom, please, my mom told me, please bring me a necklace. I will in return make your choice of food every single day. And I said, oh wow. And I brought a necklace. If you can see, there is a nice necklace drawn over here. This is a necklace. Okay, it's too big for that neck, but anyway. Now I asked her to make pizza for me, and she said, haha, she's obviously not gonna be making the pizza. She's wearing the necklace. Can I drag her to the court of law? Can I drag her along with this necklace to the court of law? Obviously not. Why? Not because she's Mother India, but because the intention, the intention of this particular agreement, be very careful with the words that I'm using. I'm not yet using the word contract. I'm still using the word agreement. The intention of this agreement was not to create legal legal obligation. We never intended to create these legal facades between us. It was just an informal contract, informal agreement, not a contract. Such informal agreements are what we call as social agreements. Social agreements. Please remember these words. These are the key words that will fetch you marks. Okay. This is what we call a social agreement, where there is no intention to create legal obligations, right? Now, is this an agreement? Is this an agreement? If you can tell me, okay, what were the steps? We have written it down over here, right? What were the steps to create an agreement? We needed an offer. Offer had to be accepted. Therefore, there were two promises made, which were consideration or quid pro quo, right? Now, in this particular example, is there an offer? Yes, mom made an offer to me. If you buy me a necklace, I will make food to you. Did I accept the offer? Yes, I accepted the offer. Did I perform my side? Yes. Did she perform her side? No. So, is there an offer? Yes, there is an offer. Yes. Is there acceptance? Yes. Are there two promises? Yes, there are two reciprocal promises. Is there consideration? Reciprocal promises? Yes. I promised to bring her a necklace. She promised to bring me an to cook food of my choice. Therefore, is it an agreement? Yes, it is an agreement. But can I file a case against mother? No. Why? Because the agreement was not intended to create legal obligations. Therefore, it is only a social agreement. Therefore, it is an agreement, but it is an agreement, but it is not a contract. Why? Why is it an agreement but not a contract? Because there is no intention to create legal obligations. Contracts are compulsorily legally enforceable. Okay, now very important word, legal enforceability. Now, in order for you to sit into that vehicle of agreement, what do you need? You need an offer. Offer has to be accepted. When the offer is accepted, what happens? Two promises come into the picture. These two promises are called consideration or quid pro quo. So, offer when accepted becomes consideration. Consideration for becomes a promise. Promise for each other is a consideration. This is what we call an agreement. Now, not all agreements will reach the final destination. For that agreement to reach the final destination of becoming a contract, one more element has to be present. That is legal enforceability. That means there has to be intention to create legal relations between the parties. What is this legal enforceability? In very simple terms, I'd like to tell you, legal enforceability means recognition of the agreement by law, right? Now, this agreement which I had with my mother, if I go to the court, if I go to the police station and tell the police that my mom is not cooking food of my choice, I gave her a necklace, will the police, will the law recognize this agreement? No, obviously not. They'll hit me, as they'll slap me and send me back home. Okay, so recognition. But on the other hand, if it was a property sale contract or a property purchase agreement with some vendor from Bombay, then obviously the police would have taken account of this and would have helped me out. So recognition by law has to be there. You can take help of law, you can take help of police, you can take help of the court of law to make the other party perform his side of the agreement. When there are two promises, if that other party is refusing to perform, if you can go and take the help of court of law, if you can go and take the help of the police to make that party perform his side of the contract, then there is legal enforceability, right? And the third thing, you should be able to file a case if the other party fails to perform. Okay, now these points, not to memorize, these are only for understanding. Okay, only for understanding. Ofu means only for understanding, right? So once again, summarizing things for you, I'm going very slow. As and when we progress, speed will increase, right? Start slowly, okay, then gradually increase the speed. First, you make a proposal. You make a proposal or an offer. You make a proposal or an offer. If your proposal is accepted, well and good, you move ahead. If your proposal is rejected, you move to the next person. Okay. If your proposal is accepted, there is a promise. There are two promises. You have promised to do something, the other person has promised to do something. When there are these reciprocal promises from one person to the other, we call this as consideration. What is the other word for consideration? Okay, now, this becomes an agreement, right? This becomes an agreement. Now, will all agreements become contracts? No, all agreements will not become contracts. An agreement which has this one element of legal enforceability, only those agreements will go on to become contracts. Okay, no problem, fine, clear. So this becomes, this is the roadway, the roadmap of how we end up on contracts. How do we create a contract? This summary is meant for you. Okay, we'll, what we'll do is, there are three definitions which we have to memorize. You have understood this conceptually, how contracts are created. Now there are three definitions which we have to memorize with the section numbers. The first definition which we have to memorize is of a promise. What is a promise? Logically speaking, from what we have studied so far, first you make an offer, you get acceptance for that particular offer. When your offer is accepted, it becomes a promise. That is exactly what is written in your legal language as well. An offer, when it is accepted, it becomes a promise. Now if you see over here, promise, the word promise, p, okay, p, if you just invert p, what does it become? It becomes b. Therefore it is 2 clause b, right? 2 clause b. Now, next definition is of agreement. Okay, what is an agreement? Okay, there is offer, acceptance, promise. Promises for each other are called consideration. This is what we call an agreement. So promises which form consideration for each other, Promises that form consideration for each other are called agreement. Agreement. Why am I stretching on agreement? Because double E. Therefore, it is 2 clause E, right? So 2 clause B was promise, 2 clause E is agreement, and last, what is a contract? Do all agreements become contracts? No, only those agreements which have the element of legal enforceability. Therefore, contract is nothing but step 2, that is agreement which is legally enforceable becomes contract. In the Indian Contract Act, what is the hot topic of discussion? Hot topic is obviously contracts, right? Hot topic H, therefore 2 clause H. Therefore, three definitions we have studied so far. Definition of promise, that is 2 clause B. Definition of agreement, that is 2 clause E. And contract, that is our hot topic of discussion, 2 clause H, right? Okay, the definitions are given here. You may kindly be requested to pause the video, read, and then proceed. Okay, all right. Now, this was our first part of the Indian Contract Act. Now, let me take you through the text. I have made all the necessary markings for you. All of this is not necessary. Okay, now, what is a contract? As per section 2 clause H. Why H? Because it is the hot topic of discussion. A contract is nothing but an agreement that is enforceable by the law, right? Therefore, agreement that has to be enforceable by law. What is an agreement? What is an agreement? If you can remember, offer, acceptance becomes a promise, promise, reciprocal promises become agreement. So promises which are forming consideration for each other are an agreement, right? Let's read the definition of agreement by clause E, right? 2 clause E. Every promise and every set of promises which form consideration for each other, right? So promise, I promise to do this, you promise to do this. Promises which are forming consideration for each other are termed as an agreement. Now, what is a promise? Promise, P ka ulta B, right? So 2 clause B, promise stands for when the person to whom proposal, that means the offer, proposal, that means the offer is made, signifies his assent. What is the meaning of assent? Assent means acceptance. Please keep making these notings in your book. Acceptance, the proposal is accepted, and proposal when accepted becomes a promise. Didn't we write this? Proposal when accepted becomes a promise. Didn't we write this already? Yes. So we wrote here a proposal when accepted becomes a promise, right? You understand it logically, you can move ahead very smoothly, right? Okay, the rest is all explanation. You can read this. These two examples, I mentioned to you that not all agreements will become contracts. Some agreements may become contracts, some may not become. What is that missing element? Legal enforceability. The agreements that do not have legal enforceability in them are called as social agreements. So if you read these two examples, pause and read, you will follow that one of them is a social agreement wherein the court of law will not recognize it, whereas the other is not a social agreement. Now, okay, so now that we have understood what is a contract, now that we are very clear with what is a contract, we now need to start a detailed discussion of the Indian Contract Act. In that, we are starting our discussion with one such section, that is section 10 of the Indian Contract Act. This section is the most important section of your entire Indian Contract Act. Therefore, you cannot forget this section till your last breath, right? Okay. Now, what does Section 10 tell us? Section 10 of the Indian Contract Act simply tells us that if you want to call yourself a contract, if you want the world to call you a contract, you have to follow certain conditions. This has to be present in you. These qualities have to be present in you if you want to call yourself a contract. Therefore, Section 10 deals with the essentials of a valid contract, right? What does it take to create a contract? What are the essentials of a valid contract, right? Section 10 talks about that. So far we have discussed, according to the current understanding of ours, according to what we have discussed so far, according to what we have discussed so far, the essentials of a contract are what? The essentials of a contract are: number one, there has to be an offer, there has to be an acceptance, okay? These become a promise. These are consideration for each other. This is an agreement. There has to be legal enforceability. It becomes a contract. This is like an unstructured understanding which we have obtained of a contract. This is like a very informal understanding, I would say, which I've given you of a contract. This is a logical understanding which we have obtained. Now we are going for a more technical understanding. We are going for a much more technical understanding of what it takes to create a contract. So section 10 tells us that in order to create a contract, you have to have one, two, three, four, five, six. Six conditions you must have in your transaction to call it a contract. Section 10, which I'm telling you is so important, is nothing but this small three lines, right? Just three lines. Let's read. In terms of Section 10 of the Act, all agreements are contracts if if they are made by free consent of the parties competent to contract for a lawful consideration with a lawful object and are not expressly declared to be void. Now, in these three lines, there are six conditions that have to be present in a particular transaction to call it a contract. What are those? Those six conditions are: condition number one, agreement. There has to be an agreement. Agreement means what? Agreement means offer plus acceptance. Okay. Now, there has to be an agreement. Okay, you've made an agreement, no problem. There has to be free consent, right? Consent is very important before you do anything. Free consent. Third, the parties to the contract have to be competent parties to the contract. Okay, this was second. This is third. Lawful consideration and lawful object, right? This is fourth, this is fifth, yeah, and it should not be declared as void. This is sixth, right? Okay, these are the conditions which we can derive from this small three line section. Now we need to understand each of them one at a time, one by one, slowly and steadily. We need to understand each of them. Number one, if we say that in order to create a contract, section 10 tells us one, 2, 3, 4, 5, 6 conditions have to be present. Number one, there has to be an agreement. Agreement means what? There has to be offer, there has to be acceptance, which becomes a promise, which is consideration for each other. So basically, what is in our hands? You must have an offer, you must obtain acceptance. Once you give offer, you get acceptance, it automatically becomes promise and consideration. So offer and acceptance has to be there. This is point number one, right? Next, you're doing all of this. I gave you an offer that you purchase my lectures. Chintu is one of the students. Chintu, right? Chintu is one of the students who wants to purchase lectures, okay? And I am over here. I give him an offer: buy my lectures. Chintu is thinking. Chintu is thinking whether should I buy or not. In the meantime, I take out a gun from my pocket and I tell him, you either accept it or you either accept it or else accept death, right? You either accept lectures or accept death. So Chintu thinks there's no other way and he pays me the fees. Okay, done. Offer, done. Acceptance, also done. He gave me his acceptance. But was this acceptance free? Was it free? Did he give his consent to me? Yes. Did he give his consent to me? Yes. but did he give his consent freely from his own wish, from his own will? No, he could not use his own willpower. Therefore, consent is required. But consent is not enough. You must have free consent. Out of his own will and own wish, he should give you consent that he wants to enter into a contract with you. This term is in legal languages known as consensus ad idem, right? You have to remember this, consensus ad idem. Now, when will you say consent is not free? Number one, in this case, if I put somebody on gunpoint and tell you I'll shoot you, you either accept my offer or you accept death. This is not free. You're not taking free consent. Or else, if I am your school teacher, y'all are my students, I'm telling you, you either sell your bike to me or else I'll fail you in the exams. I'm not pointing a gun at you. I'm not doing any physical harm to you, but mentally I'm torturing you. I'm a doctor, you're my patient. I tell you, you either give me your property or else I'll disclose your medical conditions to the whole world. I'm not doing any physical harm to you, but I'm manipulating you. I'm playing mental games with you. So, this again is not free. You're not in a free state of mind to give your consent, right? Thirdly, I'm doing some fraud with you. I'm lying to you. I'm cheating you. All of these things are not allowing the other person to make a free, unbiased, and a valid, rational decision, right? So, consent is not free in which situations? In five situations, right? Number one, in case of coercion. Number two, in case of undue influence. Number three, in case of misrepresentation. Number four, in case of fraud. Number five, in case of mistake. Now, what do these terms mean? What are they? What are they? We will discuss them in in humongous detail. There will not be a single doubt left in unit number 3, right? In unit number 3, we discuss this consent part in great detail. As of now, what are we discussing? We are discussing section 10. What does section 10 tell us? These three lines. From these three lines, what do we understand? There are 6 conditions that have to be present in a contract. Each of these 6 conditions we will further discuss in great detail, but right now we are discussing these 6 conditions in a summary. What was the first condition? There has to be an agreement, which means what? There has to be offer and acceptance. What was the second condition? That offer and acceptance should be free. It should be out of free consent. When is consent not free? Consent is not free in 5 situations. What are they? Coercion, undue influence, fraud, misrepresentation, mistake. Okay. 2 conditions done, sealed. Third condition, capacity of parties. Where was this? It was over here. Parties that should be competent to contract, right? Parties have to be competent to contract. When will you say that parties are competent to contract? If I'm entering into a contract with a 2-year-old child, is it a valid thing to do? Is it a right thing to do? Obviously not. You can't enter into contracts with children. So, in order for the party to be competent, he has to be at least 18 years above, right? This is like at least 18 years above, has to be an adult, right? A plus is not a grade, it's adult. He should not be a minor. Okay, no problem. Second thing, if there is a person who is an adult who is 25 years of age but is crazy, he doesn't have any mind, he's an idiot, he's a drunkard, let's say. He drinks and sits by the beach aram se and enters into contracts. He's very rich, so a rich guy sitting completely tight on the beach and entering into contracts to sell all of his properties. Obviously, that person is not making a rational decision. He's not able to think clearly. So the person has to be a person of sound mind, means he should not be lunatic, that is crazy. He should not be under the influence of alcohol, that is, he should not be a drunkard, and he should not be an idiot, right? Idiot has a meaning. Idiot means mad. It's not how casually we call somebody an idiot. Okay, you're an idiot, so you can't enter into a contract. It's not like that. You should be mentally insane, then you cannot enter into contracts. And thirdly, you are disqualified from contracting if the law says that this person can't enter into a contract. Then you can't enter into a contract. What are those? Few examples are alien enemy. Say suppose India declares a war with China. War with China, right? So all the companies, residents, everybody who is in China becomes our enemy because our country is at war with China, right? So you cannot enter into contracts with alien enemies. Sovereigns means the kings and queens of other countries. So still certain countries are ruled by kings and queens. Say suppose the king of Saudi Arabia, right? This particular king cannot enter into contracts with in India. Why? If you're curious, message me in person. I will tell you why. Okay. And third, convict. Convict means a person who is an offender, has done some offense, has done some criminal civil offense, and is being prosecuted in the court of law. So if you are an offender, if you have done some crime, then the law is not allowing you to enter into a contract. So what are we discussing? We are discussing section 10, which tells us a few things have to be present in order to call your transaction a contract. What are they? Number one, there has to be an agreement. That means there has to be offer and acceptance. Number two, consent has to be free. When is consent not free? In five situations. Number three, person should be competent to contract. When is a person not competent to contract? In three situations. When he is a minor, when he is of unsound mind, and when he's law has declared him as disqualified to enter into contracts. Okay, no problem. Fourth condition is about consideration. Consideration. What is consideration? Like I already mentioned to you, consideration means quid pro quo. I already told you that whenever we enter into contracts, there will always be situations of reciprocal promises. I do something for you, you do something for me in return. This return of promises, what we are doing is what we call as consideration, right? That is something in return. So when there is no consideration, when there is nothing in return, when I am saying I'll teach you law, but you're not paying me money, is it going to be a contract? No, no, there cannot be a contract without consideration. So we can simply say no consideration, no consideration, no contract. If you're not giving me something in return, I will not be able to call it a contract. It will not be called a contract. But there are some exceptions, because whenever there is a rule, there have to be some exceptions, right? So there are some exceptions which we will discuss, to be discussed later, right? We will discuss them later. Now, but the general rule says there has to be something in return. If there is no consideration, there will not be a contract. Now, very important point or a concept which you must understand is that consideration can be positive or it can be negative. What does that mean? To tell you with an example, I tell you, I let's say I'm starting a coaching academy of law, and there is already 3 4 people who are teaching law in my state, and I tell them I'll give you 10,000 rupees. They say okay, okay, what do we have to do in return? Don't teach law for the next 5 years around in this area. Am I doing something for them? Yes, I'm giving them money. Are they doing something for me? Yes, they are not teaching law. They are not teaching law. This consideration which I am getting in return is a negative consideration by not doing something. I give money to the bus conductor, he gives me a ticket. That is a positive consideration. I do something for him, he does something for me. But I do something for you and you don't do something for me, that is a negative consideration. So consideration can be positive or it can be negative. Consideration can be an act. For example, I give the conductor ticket, he gives me a he I give money to him, he gives me a ticket. This is an act that he's doing. I give you money and you don't teach. You keep your mouth shut. That is a forbearance. What is forbearance? Forbearance. The word forbearance means refrain from doing. Refrain from doing something. I'll give you money, you keep your mouth shut. I'll pay you, you don't teach. I'll pay you, you do not do this. I'll pay you, you do not do that. Those are forbearances, right? So consideration again. Consideration again is our unit number 2. So again we will be discussing all of this in great detail in unit number 2, right? Okay, this was the fourth essential element of a valid contract. Next, this consideration which we have, something in return that we are getting, has to be lawful. What is lawful? What is the meaning of the word lawful? Yes, many of you must be saying it has to be legal, right? So anything illegal you cannot do. right? You cannot have a contract wherein I pay you money and you sell drugs to me. I purchase drugs from you. The consideration that I'm getting from you is illegal, right? So illegal things will not be permissible. But this again we will be discussing in detail. There are some more, this is just the base, some more, chili flakes and oreganos are to be added to that particular pizza to make it more delicious. So we will discuss this in detail later. As of now, you have to understand that your objective of the contract, your consideration that you're getting in return, it has to be lawful. That means it has to be legal. You can't do something that is illegal. Okay, no problem. Thereafter, the law itself has mentioned certain contracts which are void. Void means not proper. Okay, as of now remember it as not proper, right? Okay, the law itself says if that particular transaction is illegal, then it is already covered here, right? It will not qualify to be a contract as per section 10. But if it is legal, the law still has the power to declare something as void. Means it will declare something, it will say that even though this is legal, but we will not recognize this as a contract. What can happen if it is recognized as a contract? If something is a contract, it is, if something is a contract, it means it is legally enforceable. It means I can take the help of the police. It means I can file a case in the court of law. It means I can go to the court of law. Understood this? So if the law is saying that even though this is legal, we will not allow this to be called a contract, it is saying that we will not recognize this transaction as a contract. You do what you want under other situations, but under Indian Contract Act, if you want something to be called a contract, you have to follow 6 conditions. There has to be Condition number 1, there has to be an agreement, that is, there has to be offer and acceptance. Condition number 2, there has to be free consent. Condition number 3, there has to be capacity of parties. Condition number 4, there has to be consideration. 5, lawful consideration, lawful object. And 6, it should not be expressly declared to be void. The code word which I use in class for these points is VLCC, the famous skincare brand. VLCC, free, offer, accept, right? So how does it work? Okay, this is VL. Okay, it's given there. This is the code word which we use in our classroom. Okay, fine. Now, this was section 10. If you read these lines, whatever I've discussed with you in the last, whatever, 20 minutes, this is what we have discussed. These 3 lines. There are 6 conditions hidden in just these 3 lines. Now, beyond this, beyond section 10, there are certain other um, okay, so beyond section 10 there are certain other points also which we need to keep in mind for understanding what will qualify to be a contract. Okay, number 1, there have to be minimum 2 parties, right? Clear? Obviously you cannot enter into a contract with your own self. You have to have somebody else. You cannot say that I promise myself to do something, if I do this I'll pay you so much, if I don't. Those are illogical things. There have to be 2 or more people to enter into a contract. Next, there, like I already, second point I already mentioned to you, there has to be intention to create legal obligations. Please write in the comments. The contracts where there is no intention to create legal obligations are termed as dash. Please mention it. Third, if there are some other formalities that have to be fulfilled, if there are some other formalities that are required to be fulfilled, say suppose you're selling a particular house, in case of a house sale transaction, compulsorily there have to be compulsorily there has to be a sale deed, there has to be a registration. Certain contracts there have to be notary done, they have to be notarized. Certain contracts like insurance, they have to be written. So these are some other formalities. Now if it is clearly mentioned that these formalities have to be fulfilled, then you have to fulfill these formalities. These are all very, very logical points, right? There has to be certainty of meaning. I cannot enter into a contract saying that I will sell books to you. There is nothing certain here. Which books are you talking about? Which author are you talking about? What subject are you talking about? What price are you talking about? The things that you're entering into a contract for have to be certain, right? And lastly, they have to be possible. Okay, possible. I cannot enter into a contract with someone saying that I'll arrange a meeting for you with God the Almighty, or else I'll bring stars from the galaxy to you. These are impossible things to you to do. Therefore they have to be possible, right? So these are some additional points which are very, very logical. The code word which we use here is two persons were performing certain legal formalities. That is, there have to be two or more persons, number one. Possibility to perform, number two. Meaning should be certain, number three. Okay. Legal, legal stands for intention to create legal obligations. That is your point number four. And last, the other formalities have to be complied with. That is your point number five. So these 5 points you have to remember if it comes in your examinations. Now, when we talk about this point which I told you about, the mother and son example, we have a very famous case law by the name Balfour versus Balfour. Okay, what happened in this case law? In the case law of Balfour versus Balfour, we had a husband and a wife. Both the husband and the wife went for a vacation to England, right? They went to England for a vacation from Ceylon, that is present day Sri Lanka. They came to England for a vacation. What happened is when they came for the vacation, the wife, that is Mrs., fell sick. She had to stay back in England. The husband had to go back because he had to earn money. So husband came back and he was sending money every month to his wife. Now husband was alone, lonely, so he happened to find a miss for himself in Ceylon, and now he stopped sending money to the wife. He stopped sending money to the wife. Now the wife went to the court of law and filed a case against the husband. She lost the case. Why? Why did she lose the case? Because there was no intention to create any legal obligations. This was nothing but a dash agreement, a social agreement. All right. This was a very famous case law, Balfour versus Balfour. So, what have we studied so far? What have we studied so far? Under section 10, we have 6 conditions: VLCC, free, offer, accept. What does V stand for? The contract should not be declared void. L, lawful consideration, lawful object. C, there has to be consideration. C, capacity of parties. Free consent, there has to be offer and acceptance. And there are some other conditions wherein we studied a word: two persons, two or more persons. Two persons were doing what? I mentioned it over here for you. Two persons were performing certain legal formalities, right? So two persons were possibility of performance, performing, certainty of meaning, certain, legal obligations, legal formalities. All other formalities have to be complied with. Okay. Now, one important concept which I would like to explain to you. First point I have mentioned here, that the contract has to be between two or more persons. What is the meaning of this word persons? Okay, we need to understand this because we have chapters ahead wherein we will require the understanding of this word persons. So persons can be of two types. Number one, we can have a natural person, that is a human being like you and me, and an artificial person, which is not a human being. We are not talking about robots here, we are talking about artificial persons. So natural persons are those that are created by natural life processes. Please don't ask me to explain anything further. For example, human beings. Okay, Artificial persons are those that are created by law and can be ended also by law. Human beings are not involved in creating artificial person. Law gives birth to them, such as a company or an LLP. We will discuss this later. We have chapters on this, right? But partnership is not an artificial person. Again, we will discuss this later. If you know this already, well and good. If not, hold on. Okay? The partnership act, partners will act on behalf of the firm. Okay. Basically, what I'm trying to tell you is persons can be of two types. You can have a natural person and an artificial person. Which person are we talking about over here? If I tell you that a contract has to be entered between two or more persons, am I trying to tell you contract has to be between two or more natural persons, or can we also have contracts between one natural and one artificial person? Please write your answer in the comments below, right? Okay. So with this, we have covered up the section 10. Okay. You can go through, I have made good notings for you. I have marked the keywords for you. These keywords, whatever I have marked, are those that have to be there in your answer. So please take care of that. Okay. Let us move ahead. Okay. So now, so far we have understood what is a contract and what are the essentials as per section number 10 of a contract, right? In section 10, we have studied 6 essentials which are given in section 10 and 5 other essentials which are not given in section 10 but which are very commonsensical, like two or more persons, intention to create legal obligations, etc. Now we have understood what does it take to become a contract. What does it take to become a contract? Those 11 conditions. All those 6 plus 5 conditions need to be fulfilled. 6 plus 5 conditions need to be fulfilled to become a contract. Now when all these 6 plus 5 conditions are fulfilled, we will call it valid a valid contract, right? We will call this a valid contract. If these 6 plus 5, any of these are not fulfilled, any not fulfilled, will this become a contract? No, it will not become a contract. In order to become a contract, you have to compulsorily follow all those 6 plus 5 conditions. If you fail to follow even one of these 11 conditions, you will never ever become a contract. You will never become a contract, never become a contract. So, what is this? What will you call it if those 6 plus 5 conditions are not fulfilled? If there is no offer acceptance, no consideration, no free consent, no competent parties, no consent, what will you call this? You will call this as void ab initio. What is the meaning of void ab initio? Please write in the comments below. You will call this as void ab initio, or you will call this as a void agreement. Please understand this very, very carefully. This concept is very, very, very important, right? If all the 11 conditions are satisfied, you will call it a valid contract. If even one of these 11 conditions is not satisfied, you will not call it a void contract. You will never call it a void contract, but you will call it a void agreement. Why will you not call it a void contract? Because it never becomes a contract. How can you call it a contract when it is not fulfilling those 11 conditions to become a contract? In order to become a contract, you have to first fulfill those 11 conditions. If you do not fulfill even one of those conditions, you will never become a contract. Therefore, we will never call it a contract in the first place. What will we call it then? We will call it either void ab initio, that is void right from the beginning, or we will call it a void agreement. Okay. Then, sir, we have heard this word void contract so many times. What is this void contract? Now, please understand, over here, this is a timeline. Say over here 6 out of 6 fulfilled plus 5 out of 5 fulfilled, right? Say suppose we enter into a contract for purchase of cotton from factory. Okay, all the conditions are fulfilled here, therefore this is a valid contract. Here what happens is the factory is burnt, right? There is a fire in the factory and the factory is burnt. Is it possible for us to perform this contract now? Is it going to be possible for us to sell the cotton? Obviously not. The factory itself is burnt. It is now not possible. Was it possible here? Yes, it was possible. Is it possible now? No, it is not possible. So once a contract is created, it is a valid contract. But if after this date of creating contract in future something happens, some durghatna happens because of which it now becomes impossible to perform, this will now be called a void contract. Okay, this will now be called a void contract, and this concept is known as supervening impossibility, which means once upon a time till this point the contract was a valid contract. But after this, something happened, some sort of an incident happened, because of which it has now become impossible to perform it. Therefore, because of this supervening impossibility, the contract has now become a void contract. So, can I say a void contract is not void right from the beginning? It becomes void after something happens. Therefore, I will conclude by saying if all those 6 out of 6, 5 out of 5 conditions are fulfilled, we will call it a valid contract. If any one of those 6 or 5 conditions is not fulfilled, we will not call it a void contract but a void agreement or void ab initio. If all those 6 plus 5 conditions are fulfilled today, but after some time something happens because of which now it is impossible to perform this particular contract, we will from that date, from the date when it became impossible, from the date of that supervening impossibility, we will call it a void contract. Therefore, never ever get confused between void agreement, void ab initio and void contract henceforth. Clear? Okay. The next discussion that we are entering into is very important again from your exam point of view, the discussion of types of contracts, right? We can bifurcate contracts on the basis of validity, on the basis of formation, and on the basis of performance. Okay, on the basis of validity, you can either have valid contracts. What are valid contracts? Valid contracts are those contracts which fulfill all the essential elements of a valid contract. Fine, section 10, all those conditions, others all conditions are fulfilled, it is a valid contract. What is a void contract? A void contract is a contract which does not fulfill all those conditions, right? No, not right. A void contract is a contract which once was a valid contract, but now it has ceased to fulfill all the conditions. Something happened because of which now it has ceased, stopped to be a valid contract. Therefore, a contract which ceases to be enforceable is called as a void contract. Very, very important. A contract which ceases to be enforceable. Can I say a void contract once upon a time was a valid contract? Yes, a void contract once upon a time was a valid contract. But a void agreement or void ab initio, was it a valid contract at any time? No, it never became a valid contract in the first place. Are we following this? I hope you are following this. Okay. So we have discussed three things so far. We have discussed a valid contract, a void agreement or void ab initio, and a void contract. Next, next type of contract which we discuss is a voidable contract. What is a voidable contract? When I say something is avoidable, something is disposable, something is breakable, something is doable, can I say there is always an option involved here? If I say it is doable, means if you want to do it, you can do it. It is breakable, means if you want to break it, you can break it. It is achievable, means if you want to achieve it, you can achieve it. Similarly, when I say a contract is voidable, when I say the contract is voidable, I'm trying to tell you that if you want to make it void, you can make it. You have an option with you to treat the contract as a void contract. Let's understand this further. Okay. So I mentioned here a valid contract. A valid contract is a contract where all the essentials, the 6 plus 5 conditions are present. A void contract, let's say all the conditions were fulfilled, but here goods are destroyed in a fire. Now the contract has become void and therefore it is now called a void contract. Now, voidable contract means able to be void. If you want to make it void, you make it void. Therefore, you have an option. You have an option. You either perform it or you do not perform it. It is up to you. It is up to you. In what situations do you think this can arise? I'll tell you. If I already mentioned to you, if I put someone on gunpoint and say, I want your scooter, you either sell it to me, you either accept my offer or you accept death. What kind of what condition am I not following here? The condition of free consent. I do not have his free consent. I have caused some harm to him. In such a situation, when we have one party, that is the aggrieved party, जिसके साथ कुछ गलत हुआ है, who has been aggrieved, affected by the actions of the other, this aggrieved party has this option. The law is giving you an option. If you want, you treat this contract as void and do not perform it. But if you want to perform it, you perform it. It is up to you. Understood this? So a voidable contract is such a contract wherein one party has an option to either perform or not perform. When the contract is enforceable at the option of only one party, right? If I put you on gunpoint, I cannot say, okay, now I don't want to perform it. Okay, I'll take it to explain it to you with a very simple example. I put you on a gunpoint and tell you, you either sell your bike to me or else I'm going to kill you. And at that point of time, you had no option. So you give the keys to me and I take the bike and go away. After some days, you go to the police station and file a complaint. You are the aggrieved party. The law will help you, the law will understand, and the law will allow you to not perform the contract. But if I have taken your bike by putting you on gunpoint and I realize that the bike was actually a damaged bike, nobody was ready to pay you 1000 also. I put you on gunpoint and I purchased it from you for 5000 rupees. I feel I am into a loss even after putting him on gunpoint. I cannot go and cancel this contract because I am not the aggrieved party. You as an aggrieved party have an option. So if you as an aggrieved party go to the court of law and file a complaint, I will have to give your bike back to you. But if you feel this mad fellow is putting me on gunpoint and giving me 5000, nobody was ready to pay 2000 also, great, let the bike go away. If you feel okay, no problem, gunpoint doesn't matter, I'm alive, let the contract go on, you can continue with the contract. Okay, this is the topic of voidable contract. Now, a contract can be voidable in three situations, right? Situation number one, where consent is not free, which I just mentioned to you, where consent is not free. Where is it? Where is consent not free? In five situations. What are those five? Please write in the comments below. Where one party is prevented from performing his promise, right? So if I have told you to repair my two wheeler, I will give you 10,000 rupees for it. After that, I don't give my two wheeler only to you. You were ready to perform it, but I didn't allow you to perform it. In such a case, the law is saying you have an option. If you want, you can cancel the contract. Third, if I have told you I will sell mangoes to you within 5 days and 15 days have passed, I did not sell mangoes to you, you have already paid money to me. If you want, you can cancel the contract because I didn't perform it in time. So did not perform it in time, right? Did not perform it in time. CPT. Okay, we call it CPT. So your foundation exam a few years before, when I gave my entrance, it was called CPT, right? So CPT means consent is not free, performance not done on time. In these three situations, the aggrieved party, who will be the aggrieved party where consent is not free, put on gunpoint. The person who is put on gunpoint is the aggrieved party. When performance prevented from doing performance, if I stop you from doing performance, you are the aggrieved party, and when I don't perform on time, again you are the aggrieved party. So all the three situations, the aggrieved party has an option to stop this contract and treat it as a void contract. So these were the three situations where a contract is voidable, right? Okay. So we are discussing the types of contracts on the basis of validity. On the basis of validity, number one, valid contract. Number two, void contract. Number three, voidable contract. Number four, illegal agreements. And number five, unenforceable contracts. So illegal means you're doing something which is prohibited by law. Okay, something which is prohibited by law is, if you remember, as per section 10, there was one condition in VLCC free offer accept which stated that your consideration and object has to be lawful. Am I right? If that is not fulfilled, your agreement will never become a contract. So if there is something illegal, will your agreement become a contract? No. Therefore, illegal agreements are actually not contracts only. But on the basis of validity, they have given these five classifications. So you have to remember it this way. And last is unenforceable contracts, which means in unenforceable contracts, there is some sort of a defect. Okay, some defect. For example, for example, say suppose some particular payment has become time barred. Okay, there are some payments, there is a act for that, the Limitations Act. If something has become time barred, it has a defect, but if you rectify this defect, it will become proper. For example, if a contract has to compulsorily be in writing, you have not put it in writing, you have made an oral contract. If you write it down, the defect is corrected, so now it becomes a valid contract. So unenforceable contract means there is some defect, but is it possible to correct the defect? Yes. Once you correct it, will it become a valid contract? Yes. Okay, no problem. On the basis of formation, we have express. Express means by way of words. You speak words, you write words, those are express contracts. Implied contracts, wherein there are no words involved, but by way of conduct of the parties, by way of actions of the parties, you understand. A coolie picks up your luggage, you start walking behind him. He has made an implied offer to you that I will pick your luggage, you will pay me. You have given an implied acceptance, you pick my luggage, I will pay you. Without speaking any words, there is offer, acceptance, consideration, promise, agreement, and contract. Are we following this? Express is where you speak words, you write words, those are express contracts. Implied is where there are no words involved, but just by way of actions, by way of conducts, we enter into contract. Quasi contract. This we will discuss TBD later. And e contracts are those contracts which are entered through electronic modes, right? Through electronic modes. For example, you must have noticed many places you have this checkbox, I agree, or else you enter into contracts online, right, with international parties. All of these, you purchase your membership of Netflix, all of these contracts which are electronically done are called as e-contracts. Okay, so on the basis of formation, how can you form contracts? You can either form contracts by way of words, spoken or written, those are express contracts. You can either form contracts by way of actions, right, like a coolie picking your luggage, like you give exact change to a conductor, the ticket fare is 22 rupees, you give 22 rupees in the hands of conductor, he will obviously give you only one ticket. There is no need to use any words, this is an implied contract. Third, quasi contract, which we will discuss later, and fourth, e contracts means which are created online electronically, right? On the basis of performance, we classify contracts into either executed or executory. Executed means what? As the word suggests, it is already done. Right now, if I am delivering lectures to you, you have to pay fees to me. You paid the fees, I gave you the lectures. Done. We have both performed our promises. We have both performed our reciprocal promises. This is an executed contract. This is a completed contract. But say, suppose I have not yet delivered the lectures to you. You have not yet paid the fees to me. This is an executory contract which is not yet performed. Now, in an executory contract, it may quite happen that I have not yet given you the lectures, you have not yet paid the price to me. Or it may happen, I have not yet given you the lectures, but you have paid the fees to me in advance. Or I am teaching you, but you have not yet paid the fees to me. In all these situations, these are covered under the law. So executory contracts can be of two types, either unilateral or bilateral, right? Unilateral means one side is pending. Either I have already given you lectures, you are yet to pay me, or you have already paid me, but I am yet to deliver lectures to you. And bilateral, where both are pending, both of us are yet to perform our promises. Are we clear with the types of contracts? Very, very simple. Okay, the notes are also available for you. I have made notings over here. Please read through. Please pause the video, read. Doubts, if any, please put in the comment section, get them sorted by me, and then move ahead, right?